We are live. Good morning. We are in Senate Judiciary at May 7th. We're taking up H 937. We have Judge Zone in the Zoom with us to talk about a proposed amendment network, the same amendment we had talked about yesterday. I want some additional information on. Judge Zone, thank you for joining us on short notice and
Pleasure.
Share your perspective on what we heard yesterday. That would be great.
Sure. So Tom Zone, Chief Superior Judge. I am looking at H 628. As my understanding is that what the committee was looking at was potentially bringing 628 into H 937. Under 628 had really, I'll say, two parts. The first part was changing a provision where it currently says that the court can make orders if it finds that the defendant has abused the plaintiff and there's a danger of further abuse. And what it currently says is, or the defendant is currently incarcerated for certain crimes. And the first part was to change the word incarceration to be under the supervision of the Department of Corrections and leave the rest of that paragraph the same. That's a policy decision, and it certainly is something that the courts can work with if that's something the legislature decides to go in that direction. Second change is adding a provision for potential orders. And I want to be clear, when a court under the relief from abuse statutes is entering a final order, it says under section 1103C1, the court shall make such orders as it deems necessary to protect the plaintiff or the children or both. And that language has to guide the court when it considers what terms it is putting into an order. In one case, something may be necessary for protection, in another it may not. So the court has to be guided by the idea that any order has to be necessary for protection. And the order that the court does is it's based on a summary proceeding. The idea of the relief from abuse proceedings is that it is a summary proceeding to provide immediate and necessary protection for individuals to prevent further abuse. And the legislature has enacted certain provisions that the court can impose under such an order. One of those provisions currently says that if the court finds that the defendant has a duty to support the plaintiff, the court may order that the defendant pay the plaintiff's living expenses for a fixed period of time not to exceed 3 months. Under Title 15B, the Section 1102, Definition 4, defines duty of support to mean an obligation imposed or imposable by law to provide support for a child, spouse, or former spouse, including an unsatisfied obligation to provide support. The amendment that is sought would add a subdivision F as in Frank. The amendment, as it's worded, says that the court could also impose an order that the defendant continue to pay household bills for which the defendant was responsible at the time the plaintiff requested the order for a fixed period of time. And so the two things this provision does: one, it expands who is able to potentially receive financial support from this summary proceeding from individuals who are, we'll say, the immediate family members from marriage or children. And it makes it a much broader for anyone who has been involved in a family or household type relationship. The court could order this. The amendment also does not contain any time limit. It, unlike subdivision E, does not say not to exceed 3 months. This could theoretically go longer. The purpose of the relief from abuse proceedings, again, is for protection. It is not a divorce. It is not a separation. And it's not a, I'll use the term palimony or a relationship, something to get to exchange personal property and financial arrangements between an unmarried couple. If this amendment were to go through, the court would have some questions it would have to address in connection with the case. If a plaintiff is seeking protection under this in terms of monies for bills, the first question the court would have to decide in the summary proceeding is, was the defendant responsible? That's undefined in the bill. What does responsible mean? Does it mean legal responsibility? In other words, does it mean that the defendant had to have been on the lease? Or could it mean that the defendant and the plaintiff had an agreement where the defendant would pay a certain bill? And so the court would have to look at that and determine through evidence who is responsible and what is really the standard. Is it a legal responsibility, or can it be just the agreement of two parties? You pay the rent and you pay the electric, and I'll pay for the food, automobile. And the question for the court would have to answer is, where is that line as far as responsibility from the statute? What happens if both parties are legally responsible and haven't been paying the bill for 6 months or 9 months? Ability to pay is not something that the statute provides, but I would suspect that courts would look at it. And it's important to keep in mind that the court cannot change obligations to third parties. In other words, if the plaintiff and defendant are on the lease, and the court were to order the defendant to have to pay it to the exclusion of the plaintiff is still obligated to the landlord, and the court can't remove that obligation. And so there are questions as to how this would play out in practice if the court were to enter such orders. The question that arises is something like this, is it already provided for in the law? And the answer is no, because if an unmarried couple came in for relief from abuse and a plaintiff were to ask the court, well, the other party was supposed to be paying the rent and they're not doing that and they're on the rent, what the court would generally say is, well, that's a separate action. You'd need to file that in small claims or bring an action in the civil division. We don't have authority to decide that. Because again, the idea of the relief from abuse proceedings is a summary proceeding that is designed for safety, and it's not equipped in that summary proceeding to decide, and it's not used to decide, we'll say, financial matters. It's used, as that subsection E provides, really for a stopgap, to get something in for protection, some money, duty of support, before someone can file for divorce. And that's why I suspect that 3 months is there, because once someone files for a divorce, generally there's an interim domestic order which requires the parties to continue to pay the bills that they were previously paying.
Judge Zoning, question from Senator Bowles.
Thank you. I really appreciate that. It was, as always, very clear and helped me to understand sort of the differences. Given that we're, I think, like everywhere in the country, seeing more and more long-term relationships that don't involve a marriage. And I think the intent was to protect those relationships. As we know from the fight for marriage equality, marriages provide you a set of protections that you may not have if you don't have that legal contract. And so I'm wondering, as I hear you, that there's a little bit of a lack of clarity. If there's another way that could be worded to do what it's intended to do, that was more clear for the courts.
I was wrestling when I spoke to the House Judiciary in early February. One of the questions came up about what does responsibility mean, and I think one of the reps said, well, their mind was that the responsibility was a legal responsibility, as opposed to a contractual responsibility. And then I thought, well, and afterwards I thought, well, wait a minute. a contractual responsibility is still a legal responsibility.
Yeah.
And I say that because if you just added the word, which the defendant was legally responsible, well, if there's a valid contract, they'd be legally responsible. So I don't have any real, if you will, fix for that. The court will have to decide this in the individual cases and determine what's there as far as agreements, how far to go. Obviously it's a policy decision, but I don't think from the way that's structured that the intent is to have F be something that is really almost a different type of divorce or separation agreement. So maybe having a time limit like subsection E would be helpful, because it would prevent any potential for things to really go. Because if the idea is just to provide safety, not really address the financial matters, but give someone the ability to give some time, adding a time frame could be helpful there for everyone to be on the same page.
Thank you.
Thank you. Judge Zone, do you have additional testimony? Committee, any other questions for Judge Zone? Okay. Shell, thanks again for your time. Appreciate it.
Have a good day. Take care.
Want to join us? So my initial take is, it's my preference. I know we have two proposals of amendment from the network. The first amendment was to change, replace the word incarcerated with the word under the supervision of corrections. Personally, I'm good with that change. I think that's fine. And then we have a second amendment, which we heard it's more so about Judge Zone. I think there are unanswered questions as to how do we define responsibility and how do we determine whether or not a defendant was responsible. I think those are meaningful conversations that we should have and figure this out, but I think it is more substantive than we'd like, or than I would like for a miscellaneous bill. So I would prefer we don't move forward with that second amendment, but I'm definitely open to revisiting it for a larger conversation next year, assuming we're here. Any other thoughts?
I agree with what you just said, first amendment versus the second amendment. I think their second amendment. I think it needs more discussion and the intent and the theory behind it. I agree that needs.
I think what we just heard from Judge Zone is there is no better way to define responsibility, and that the real sort of clarity would be adding the time frame back in. So I don't know that more discussion is going to get us to a better definition. After court's sake, a better definition.
That wasn't my takeaway. And
I support what you said.
right. Thank you. So we can move forward with that and just the first amendment without having to change it to the P conversation.
Great. So for the record, Michelle Childs, Office of Legislative Counsel, and it sounded yesterday during your discussions that you were going to be okay with that first amendment. So I went ahead and, we got 2 days left. So I went ahead and incorporated it in here. And everybody should have a copy of draft 7.1 of the individual instance of amendment. And so I'll just do kind of one last pass through here to remind everybody what's in here. So looking at draft 7.1. So the first sentence of amendment is the tweak to the underage possession of alcohol or cannabis statute. Just clarifying that when you added that 0.02 offense last year, that immediate suspension only applies in that case, right? So you could have someone that winds up getting their driver's license suspended for a certain period of time, but that's only if they either fail to report to diversion or they don't successfully complete diversion. The only automatic suspension is if you have an underage person with a 0.02 operator.
Actually operating a vehicle.
Yes, correct. So the second instance of amendment, this is deleting that section that you had came over from the House around the tobacco and the minimum age of 12, because that's being dealt with in S-198. The third instance of amendment is just fixing a technical typo and changing in the provision that has to do with the renewal of family division judgments. There's just a typo and it's changing out and striking out affirmation and putting affirmative. Fourth instance of amendment, these are your new sections that do not appear in the House passed version. The first one is in section 40A is with regard to the ability for victims to opt out of certain notifications and services from DOC, and Hillary talked to you about that. On page 3, section 40B is the language from the home improvement fraud bill. Page 4, line 13, section 40C, that's the technical to 840H849 that you just passed, just clarifying that the State Court Claims Act does apply. So clarification language. Page 5, section 40D is just tweaking that language on the tenant representation pilot program. Oh, sorry.
Mr.
Yes,
Chair,
sir.
I'm sorry, can I go back to page 3? I noticed that in line 6 through 12, it's a single sentence, but have the word no in there twice now. And I'm wondering if that's purposeful. So, it seems like one or the other would do it.
So I think the intention there, and I'm trying to remember because it's been a while since we worked on that, was just making sure that it's applying to both provisions here so that it's clear that that you're knowingly entering into the contract and then knowingly doing the second part. So right, there's two pieces to that.
Mhm.
And the intention of this was just going to the original language of what it looked like before those 2015 amendments, which there were a few in there, but then, you know, kind of resulted in the some of the issues with the cases in the lower courts.
Mhm.
And so it's just reverting back to that language. So I would say at this point, this is what had passed out of the body before and was agreed upon
Yeah.
between with DSAS and AGO. So
Okay, because I saw that you were inserting knowingly on 7.
but this is the exact language that already has been vetted and
I
passed.
see.
So
Okay.
that was.
Great.
So back to page 5 on section 40E. On the, and remember, we talked about this yesterday on the tenant representation pilot program. It was passed in the 23 Act, but had the contingency language around funding. It wasn't funded till FY25, and so we're just tweaking the dates in this particular section because it didn't wind up starting until November of 24. It also makes the change where it was originally created for Lamoille and Windsor counties and allows it to be applied statewide. Then on page 7, you'll see that that is amending the big bill from 2024, and where the language that was originally the money that was appropriated for the pilot program, and just adding that it's carried forward so that they can continue to draw from that. And that is the way JFO suggested that it be raised in a particular provision. Section 40F And 40G are the provisions with regard to the Human Rights Commission that you guys have been working on for the last couple of weeks. And then the very last section is on page 10, in the new section 40H. And so this is the amendments that we were discussing this morning, which is in the civil protection statute for domestic orders. Remember, we're looking at the standard there. One, there has to be a finding that the defendant abused the plaintiff. And two, there's a danger of future abuse, or, and right now it says the person is incarcerated, and it would just be expanding it to be, it would also include folks who are being supervised in the community as well.
Any questions on these? No? So I did just want to go back. The bill is passed by the House, and please give me the highlight again regarding the spendthrift provision. I think it's section 20 on page 22.
Say section 20?
Yeah, section 20, page 22, as passed by the.
There's notes on that. Okay, section 20 repeals all the Vermont statutes related to a type of guardianship called spendthrift guardianship. These guardianships were once used when a person could not manage their own affairs, specifically quote on account of excessive drinking and gambling, idleness, or debauchery. Ooh. These statutes are archaic and no longer in use, so the Judiciary's Advisory Committee on the Rules of Probate Procedure asked that they be repealed.
Is there a legal definition of debauchery?
I don't know. There is a Black's Law legal definition that was used in the statutes, but we do try to clean those up when we see them.
And one more question, page 27, line 10. Will you remind me of what lines 9 through 10 do again, the addendum clause?
So section 26 was requested by the BPA and involves the transfer of jointly owned property. This is done most commonly in two ways, either through a joint tenancy or through a tenancy in common. The primary difference between the two is what happens to the property when one of the owners dies. In a joint tenancy, the property passes on to the surviving owner, whereas in a tenancy in common, the property passes to the heirs of the owner who died. Section 26 responds to a recent Vermont Supreme Court decision holding that certain deed language should be interpreted to mean that the property is owned as tenants in common. The Bar Association, Vermont Title Company, and the Vermont Bankers Association all agree that this language has instead always been read to establish a joint tenancy. So section 26 is amended to make that interpretation clear.
Any other questions, issues? So the logistical note, Senator Matos is unable to join us except via Zoom at 10:30. And so we'll save all of our votes, including for 9:37 or around 10:30. So if everybody could be here at around that time, that would be great. Would that work for everybody? Sure. Okay, so we'll vote on this at around 10:30. Thank you, Michelle.
And we're adjourned till then?
We can take a 5-minute break. Then.
Okay.